Oh, really? Oh, thank you. You're pretty easily influenced. Yes.
Man, see it. Come to order. For a second session. You got a cell phone. Make sure it's turned off. Put on vibrate.
All right, council, where are we? Judge, the council is supposed to go to scheduling before for this afternoon. No, I don't think it's on.
I just stuck on the calendar. I need to talk to the judge about the schedule.
What you got? Where'd you sleep? Thank you, Your Honor.
All right. So,
Your Honor, I have two documents that I would like to tender to the court. I've marked the first as hearing exhibit number 40, which is a copy of the SBI, the request for examination of physical evidence, where the Durham Police Department submitted I believe it's 68 items to the crime lab for analysis. And our exhibit 41, which is the State Bureau of Investigation laboratory report relating to DNA analysis of various pieces of evidence and the results therein. And I offer those to the court.
No objection, Your Honor.
all right,
If I may, I'll hold them here for argument purposes.
all right.
Okay. At this time, Your Honor, we defer to the state.
Your Honor, the state will move to introduce into evidence State's Exhibits 1 and 2, which were previously referenced. One being the report signed by Mr. Palmbach, as well as number 2 being a video for which was used during the cross-examination of Mr. Palmbach.
All right.
And Your Honor, additionally, the state has marked the State's Exhibit number 3. I spoke with counsel during the break. This would be in digital form, the trial transcripts of State versus Michael Peterson trial, containing volumes 1 through 78. I have not printed those out, Your Honor, as the total volume is 13,423 pages. But the state will move to introduce the evidence for purposes of this hearing to establish a record, the trial transcripts.
So,
Thank you, Your Honor. If I can just approach out and give that to the clerk. That'll be evidence for the state, Your Honor.
all right. She says she deferred to the state.
Okay. Well, Your Honor, defense counsel has made a motion dismissed, and we're looking at, is there a due process violation?
Yes.
We're looking at whether or not...
You don't deny that some of the evidence was mishandled in some way.
Your Honor,
You showed Mr. Rudolph.
Yes, I would say, Your Honor, that the photos of the evidence within the clerk's office speaks for itself. When that happened, we don't have any evidence other than the fact that it would have happened. We know from the testimony that it clearly did not happen while in custody of the police department, or
So you know, like I know, when defense counsel knows, at least in the state of North Carolina, the defendant is not guaranteed a perfect trial. He's not even guaranteed a mistake-free trial. So, assuming that you agree with that, why do you say the defendant can still get a fair trial? I presume you believe he can get a fair trial.
Your Honor, what I'm looking at is whether or not under 15A268, subsection G, there should be a dismissal, or under or whether or not there's a due process violation. And that's what we're looking at as far as under 15A 954, subsection 4, when the defendant's constitutional rights have been flagrantly violated and there's such irreparable prejudice to the defendant's preparation of his case that there is no remedy but to dismiss the prosecution. And it's that for which the motion to dismiss is based, Your Honor. Your Honor, when we look at that, we look at what are some of the things or facts that have been gleaned. Some we don't have answers to, but some we do. We know that the evidence that is an issue here, the evidence that was submitted and introduced into evidence at trial, and then came into custody of the clerk, that there's been issues regarding his present state and the ability to test those items. That prior to the trial, these items were brought to the attention of the defendant. The defendant was aware of the existence of the clothing, was aware of both the victim, Kathleen Peterson, as well as Michael Peterson, as well as items of evidence regarding Mr. Todd Peterson. In fact, not only were they aware of it, but Dr. Lee and Mr. Palmbach visually examined these items and examined them under magnification, under different lighting, for purposes of blood pattern analysis. They knew that these items existed. They knew that by its very nature of blood pattern analysis that there's blood on them. Now, the defense is under no obligation to perform any independent testing, but they weren't denied that ability by the state. That we've heard during the testimony of Mr. Palmbach, either through questioning or through the answers of the witness, that the state did not perform any DNA testing as it related to the clothing of Kathleen Peterson. Your Honor, if I may approach, there's a couple cases which referencing copies to defense counsel as well as to the court reporter, so we can make reference to these from the court. Well, the first case that the state will be referencing is the case of Arizona versus Youngblood. This is 4888 U.S. 51, decided by the United States Supreme Court. And that was decided back in 1988. And Your Honor, they made a reference and talked about due process. And when we look at Rule 28G, I mean, no, the 968G, it says that the court finds the destruction, in this case we're talking about evidence within biological evidence, finds that destruction violates the defendant's due process rights. The court shall order an appropriate remedy, which may include dismissal of charges. So, violated the defendant's due process rights. We contend as well, Your Honor, that when you're looking at 15A954 subsection A4, that when we're talking about the constitutional rights have been flagrantly violated, but we're looking at due process rights. And under Youngblood, the U.S. Supreme Court talked about due process violations and what constitutes a violation under due process. The reference about whether or not there was a Brady violation, and it talks in reference to, and this would be what's listed as LEDHR1A, the due process clause of the 14th Amendment as interpreted in Brady makes the good or bad faith of the state irrelevant when the state fails to disclose to the defendant material exculpatory evidence. But we think the due process clause requires a different result when we deal with the failure of the state to preserve evidentiary material of which no more can be said than it could have been subjected to tests and the results of which might have exonerated the defendant. And it continues on and states, we therefore hold that unless a criminal defendant can show bad faith on the part of the police, failure to preserve potentially useful evidence does not constitute a denial of due process of law. So first, what is it that we're claiming? What is it claiming? That could be tested for DNA. That although the test could be performed, that Mr. Palmbach indicated that they could not be relied upon, but he can't say whether or not there would be any DNA on there. He can't say that previously there had been any DNA on there that would have been exculpatory. All there is the potential. And based on Youngblood, the language there fits exactly with the scenario in this case. That would be the state's contention. That we're dealing with a failure to preserve evidence, which no more can be said that it can be subjected to tests and the results of which might have exonerated the defendant. There's nothing inherent within that, within these clothing, which would tell us that this definitely is exculpatory. In fact, when questioned about the evidence, Mr. Palmbach indicated he didn't see any, you can't see any DNA that may fall off. You can't see it with the naked eye. He indicated that he didn't see any areas of the clothing where there had been any rip, and therefore areas that you should be looking at as far as potential third-party DNA. He did indicate that in fact there was copious amounts of blood, and that resulted in the examination of the items for blood pattern analysis. But that is not exculpatory in and of itself. What he's indicating on is that he doesn't know what's on those items of evidence. And therefore, that is potentially helpful to the defendant. But that's all it is, it's speculation. And therefore, Your Honor, we have to go to see whether or not there's bad faith. And in Youngblood, Your Honor, that was a case in which there was a sexual assault of a young man, of a young boy, that there were swabbings taken of his rectum, there was clothes that were recovered, and they weren't stored properly as far as refrigeration, that the testing did not result in anything conclusive. The clothes could have been tested pursuant to new tests that were available. In fact, I believe it was referred to as the newer P30 test. And under those scenarios, the court did reference different things. One, in reference to the fact that the state did not previously test Kathleen Peterson's clothing. It is correct. If it had been tested before, we wouldn't be dealing with this issue. It wasn't tested. It was sent off. It was subject to blood pattern analysis. And quite frankly, then was not altered or destroyed. It was maintained. It was maintained in packaging in a manner that, according to Mr. Palmbach, he would expect. The integrity of those items were kept free of alterations and contamination, such that they could be examined by the defense, if the defense so chose. And the defense did choose as related to the blood pattern analysis, which ultimately was the defense at trial. Present counsel is not bound by the prior defense strategy. They do have to deal with the evidence that has been presented here during this hearing. And I'll get that in a bit. But in reference to the fact that the state did not conduct testing, that is not a constitutional violation. It is not a violation that will resort in a due process violation. Your Honor, the state at trial has a burden of proof. The defense does not have a burden of proof at trial. But we're not at trial. We're at a motion to dismiss. And as a moving party, the defense has the burden. And in this case, Your Honor, I'm referencing the second case, State versus Dorman, that is 225 NCAP 599, decided in 2013 by the Court of Appeals here in North Carolina. As a movement, the defendant bears the burden of showing the flagrant constitutional violation and irreparable prejudice to the preparation of his case. And that's referencing 15A954A4. So at this stage, in this hearing, the burden of proving the prejudice.
Well, who, by the way, was the judge in that case?
In the Dorman case, I believe you were, Your Honor.
Mm-hmm.
And in fact, the court did commend you on your diligence in addressing the rights of
They also ruled against me, too.
Well, Your Honor, none of us bat 1,000. So, but that would be referencing the fact that the state of North Carolina is following that which is set forth in Youngblood. And Your Honor, just dealing with this issue because it was brought up, in Youngblood, as indicated, there was a newer test that could have been performed, and the state did not perform that test. The United States Supreme Court referenced the following, and this is in, it's kind of easier, I think, to go backwards. This would be right at the end of the majority opinion. The next to last full paragraph says, Arizona Court of Appeals also referenced somewhat obliquely to the state's inability to quantitatively test certain semen samples with the newer P30 test, and then references the case. If the court meant by this statement that the due process clause is violated when the police fail to use a particular investigatory tool, we strongly disagree. The situation here is no different than a prosecution for drunken driving that rests on police observation alone. The defendant is free to argue to the finder of fact that a breathalyzer test might have been exculpatory, but the police do not have a constitutional duty to perform any particular test. In that case, we're talking about testing purposes of semen samples, and there was no constitutional duty to perform any testing. What was also referenced in Youngblood, Your Honor, was that the existence of these tests were not hidden from the defendant, and in this case, none of the physical evidence that is now at question, the clothing, the potential for biological evidence on that clothing, none of that was hidden or concealed from the defense. And the U.S. Supreme Court stated none of this information was concealed from the respondent at trial, and evidence such as it was made available to the respondent's expert, who declined to perform any tests on the samples. Your Honor, everyone has their own strategy, and the defense made a decision not to do any testing. That is their choice. They're not bound or obligated to do so. But when we're looking at a due process violation, the question is, were they provided with the opportunity? And the way you're provided with the opportunity is, one, you have to be made aware of it. Two, this evidence has to be packaged and maintained in such a manner that you can have confidence in its integrity. And according to Mr. Palmach, when he looked at it and was made aware of it and visually examined it together with Professor or Dr. Lee, rather, it wasn't exactly the condition that he would expect it. there wasn't contamination, it was being maintained in a proper manner. And therefore, Your Honor, the opportunity, the knowledge, and both the knowledge and opportunity was present for the defense at that time. The decision not to do so was a strategy made, and now here we are. But the opportunity was present. Your Honor, when we look at bad faith, and we have to look at it as far as what did happen here, and some of the things we don't have answers to. I know we've heard from Mr. Palmbach at this hearing. There was a previous discovery motion that evidence has been presented at this hearing. The defense counsel wishes to incorporate it, that being the motion for discovery related to the evidence from the clerk's office. I would object to that. If not, then I'm not making a motion to include it. But what we know is that we don't know when the evidence as depicted in those photographs got in the condition that it is. What we do know...
Yeah, right. What did happen?
It calls for speculation, Your Honor, and I believe Mr. Palmbach...
You might recall many months ago, at the beginning of this hearing, the first question I asked Ms. Darrell was, what was the burden of proof? First of all, I asked her who had the burden of proof. She told me that she believed the defendant had the burden of proof. And I asked her the burden of proof to show what? I asked her, had a case ever been dismissed in the state of North Carolina since that statute has been in existence? And she didn't say she didn't know. What she told me was she couldn't find one. And what I told her on that day was, neither could I. And so what I wanted to know was, first of all, what was it that the clerk, Archie Smith, what would be his responsibility under this statute? What kind of violation by the clerk? We're not even talking about the district attorney's office at this point. What kind of violation by the clerk should end up in the defendant getting relief? Now, Ms. Darrell has in a whole lot of ways that she says the clerk should have handled the evidence, but I think both of you all have to address what it was that the clerk was responsible for doing. There are at least several things. He had to not intentionally destroy evidence, and I don't know that there's been any evidence presented that the evidence was intentionally destroyed or damaged. What is lesser than that? Is there some kind of negligence that can give the defendant relief in this case? Now, remember what Mr. Smith testified to and all his clerks. They didn't do anything intentionally. I don't think the evidence is that they knew about destruction. Now, I don't know, that's something you all can argue, but I think there's an issue as to what the legislature meant when they passed this statute. What were they trying to protect against? I think that gets, we have to deal with that before we deal with what happened in the trial of the case and any malfeasance that may have happened. I don't even know that we know what the legislature had in mind.
Let me address that, Your Honor.
Yes.
Your Honor, when this trial occurred, it occurred in 2003. statute that is being referenced here, we're not gonna argue it's not retroactive, but it wasn't enacted until years later. So if you have the event that has resulted in the evidence of the condition as shown within the photographs, then how can we say that at the time in which 15A268 was enacted, that the evidence wasn't already in that condition? And it's one of those scenarios that once that bell is rung, it cannot be unrung. You can't go back and say, let me put it differently. And so when we look at 268 as it reads right now, and did not read back in 2003, at the time in which evidence was presented at trial, now it talks about there can be an order of the court designating items as biological evidence. There is no order in this case, because, and the reason why is because this law wasn't in effect then, and therefore none of the parties, including the court, would have had any reason to do that. The law just wasn't the way it was, or rather the way it is. Therefore, Your Honor, when you look at, it's the state's contention that when you look at 15A268 as it applies right now, what we're looking at is A1, which reads, notwithstanding any other provision of law and subject to subsection B of this section, a custodial agency shall preserve any physical evidence, regardless of the data collection, that is reasonably likely to contain any biological evidence collected in the course of a criminal investigation or prosecution. Evidence shall be preserved in a manner reasonably calculated to prevent contamination or degradation of any biological evidence that might be present, subject to a continuous chain of custody, and securely retained with sufficient official documentation to locate the evidence. That didn't exist. Back, A1 did not exist in the wordage back when, in 2001, when 15A268 was enacted.
That means to me that certain responsibility that the clerk of court had didn't exist. Statutorily, it didn't exist.
Statutorily.
Yes. Constitutionally,
No,
it may have still.
that's a different issue. And when we look at 15A268, it talks about back in 2001, notwithstanding any other provision of law and subject to subsection B of this section, the governmental entity that collects evidence containing DNA in the course of a criminal investigation shall preserve a sample of the evidence collected for the period of time the defendant convicted of the felony is incarcerated in connection with that case. The government entity may determine that the evidence is retained pursuant to the section, provided that evidence is retained in a condition suitable for DNA testing. But once items of evidence are introduced at trial, according to the rules of court, that is Rule 14, it's no longer within the custody of the investigative agency. It goes to the clerk and maintains within the custody of the clerk until either the sentence is completed and the appeals are over with, or, Your Honor, well, until the appeals are run or the sentence is run. And
I think that's probably always been
I think that was a practice, that's what happened.
the law even before me and you
Yeah.
passed the bar.
And certainly that can be revisited in the future. But I think that as time goes on, and we think about the evolution of DNA testing, things that we look at now and say, well, you shouldn't be doing that. Back at an earlier time, wouldn't seem unreasonable at all. And Your Honor, when we look at, in this case, what was done with that evidence, and I believe there was speculation on the part of Mr. Palmbach, indicated, well, these bags are open, they're put in the same box, and then they're being moved around. And if they're being moved around, then items can start commingling. But that's not an intentional act by anybody. That's just moving boxes around, and it may just be a moving company that's doing that, as you're moving from one location to another. It may be an individual is moving it from one floor to another. And that doesn't rise to the level of bad faith on the person who's moving those items around. Especially when you look at State's Exhibit number 2. In State's Exhibit number 2, there was a video, and I asked extensive questions, and that showed an agent of Mr. Peterson, his attorney at the time, David Rudolph, who wasn't just handling items with his bare hands, with his fingertips. He was brushing them along, he was folding them, he was putting them on the bar, he was taking another item of evidence, another piece of clothing, commingling them, and putting them in a bag. And we look at it now, like, that's definitely not the way you should be doing that. Well, I can only speculate, Your Honor, but when you look at the defense that was presented, there was a prejudice in that, because the defense isn't third-party guilt, it's a flaw, it's an accident. And therefore, they've already had the opportunity to do all the examinations as it relates to blood pattern analysis, which would support the theory of a flaw, and they're not looking at third-party guilt. And if anyone in that courtroom has suspected, I suspect if anyone in that courtroom had thought for a moment that there's some prejudicial effect by what Mr. Rudolph is doing, then someone would have spoke up. But nobody did. I'm sure the court would have done it on its own. Mr. Harder would have done it, Ms. Black would have done it, but nobody did. So why should the clerk think for a moment that here we have the attorney for the defendant taking these items and commingling them and putting them in a bag, to think that okay, why can't I put all these in the same box? And they're not even commingled, they're in a separate packaging, albeit it's over. It's not been taped back up, but it's still within the same box. When you have the defense attorney jumbling them together and putting them in the same bag, he may have been trying to make a point, but in the process of doing so, spoke volumes to everyone else in that courtroom, that there was no worry about prejudice on his part, because that wasn't his defense. And clearly, present counsel isn't bound by that defense. But this goes to the state of mind of what happened in regards to the actions of people afterwards. It does happen occasionally, but it's rare that we have a murder conviction overturned by a motion for appropriate relief. You receive motions for appropriate relief all the time, and most of them are denied. At the time of the trial, could any of us have foreseen where we would be today? That there would actually be a motion for appropriate relief granted. Your Honor, it's the state's contention that Mr. Palmbach is correct as far as how these items got in the condition. They've been put in a box and moved around. The box has been moved around. Not someone going inside and tearing them apart and moving them around. There's been no evidence of that. And that does not rise to the level of bad faith on part of the clerk's office. And that's what needs to be shown if you're dealing with evidence which is not Brady material, but it is potentially. So under Youngblood, if it's not Brady and there is no bad faith, then there is no due process violation. And if there is no due process violation, then 15A 268G, which talks about destruction of evidence in regards to the defendant's due process rights, that doesn't kick in. And nor does under 15A 964A4, as far as a violation of the defendant's constitutional rights. Your Honor, I indicated multiple times, the defense counsel is not bound by the defense that was used at trial. But even here, their own witness that they presented here before this court, when asked about, based on his expert opinion, whether or not he still stood by it, was this an accident? And this is why I got into this, Your Honor. He's saying it's an accident. He's still saying it's an accident. And saying that if it's an accident in which he believes in that the evidence is inconsistent with an assault, and certainly the state disagrees with him, but this is their witness, their evidence. And based on their evidence, it's showing that the DNA, if there's any present at all, will not affect in any way his determination that this is an accident. and therefore would not be prejudicial to the defendant. Your Honor, for these reasons, the fact that this is not a Brady violation, that what is contained on that clothing is speculative, and therefore is not Brady, that under young blood, when you're dealing with a scenario such as that, where items could have been subjected to testing and could possibly have produced some evidence, but we don't know, then there has to be a showing of bad faith as far as the actions that rose to the event of getting the evidence in the condition for which it is being documented in the defendant's photographs. And we don't have that bad faith. And it's for those reasons, Your Honor, that the defendant has failed to meet his burden for purposes of this hearing, and showing that there's been a due process violation. And therefore, Your Honor, the state would ask that you deny the defendant's motion to dismiss.
Well, let me ask you this, Mr. Dornfried. What if I do that? What if I deny the defendant's motion and this case goes to trial? Can defense counsel still raise all of these issues in front of a jury?
Yes, Your Honor, I believe that.
Not on the same grounds. I don't believe that she would argue a statutory violation, and I don't think she would technically argue a due process violation to the jury. But can't she still do the same things, call the same witnesses, and make a similar jury argument on Mr. Peterson's innocence?
Yes, Your Honor, I believe, and in fact, that's what was referenced in Dorman.
Which would be similar to what a defense counsel could do. Say it was a motion to suppress, and she would be attacking the fairness of the process. She might not be able to argue to the jury that the confession shouldn't come into evidence. That issue's already been decided by the court, but she could still raise the fairness issue. It seems to me in a similar way that she could still raise the issue about the condition of this evidence to the jury.
Yes, sir.
I'm not sure a finding by the court would really stop her from raising it at trial.
Yes, sir.
But she's been practicing a whole lot. I mean, she knows she wouldn't be bound by whatever I said, but at least I hope she would never. So are you finished?
Yes, sir.
All right. Yes.
Thank you, Your Honor. First of all, to go back to the beginning of the state's argument and the question you asked, there are regulations. They were identified by the clerk of court. First of all, there is a School of Government document entitled Clerk's Handling of Evidence, and Mr. Smith testified that they followed that. Specifically, one of the sections sets forth how evidence is to be stored, and it goes through it in detail. Biological evidence must be preserved in a manner reasonably calculated to prevent contamination or degradation of any biological evidence that might be present, subject to a continuous chain of custody, and securely retained with sufficient official documentation to locate the evidence. And that was not done. There is nobody that disputes whether or not it was properly stored. So there are regulations that were followed, and this document, the clerk's handling of evidence, is based in large part upon the statute, which calls for custodians of custodial agencies to follow these rules as set forth by the Administrative Office of the Courts. And this document from the School of Government, it was done, as I understand, in tandem with the Administrative Office of Courts. It's what the clerks of court use. It is evident, and it was evident in August, however, that this clerk of court, and it may be every clerk of court, I do not know, but that these procedures are not being adhered to and followed. Now, I would note, in discussing 15A268, I did a quick check, and unless I'm mistaken, that was first enacted in 2001. Therefore, when this went to trial in 2003, the law was already in effect, setting forth the duties and responsibilities of the custodial agencies. And I would note, first of all, that Mr. Smith acknowledged, when called to testify in August, that the clerk of court does qualify as a custodial agency, because once evidence is introduced at trial, it is indeed in the custody of the clerk of court. That makes them a custodial agency. And it says...
So what kind of acts are prohibited by the statute? We know an intentional act is the clerk can intentionally destroy evidence for the purpose of preventing a defendant from receiving a fair trial. What less of that could you get, you meaning a defendant, get relief from under the statute? Does it have to be, is it only an intentional act?
No. The statute says the court may conduct a hearing to determine whether obstruction of justice and contempt proceedings are in order. But then it goes on to say, if the court finds the destruction violated the defendant's due process rights, the court shall consider an appropriate remedy, which may include dismissal of charges. And our position is, Your Honor, there's no requirement for bad faith in the statute. The statute allows the court to dismiss the charges, which is what we are asking for. But there is no requirement of bad faith violations. It is a question of due process. However, if I may go back, during the first trials, as what I saw on the court TV video, Exhibit 2 that the state introduced, Mr. Peterson's attorney, David Rudolph, did indeed hold Mr. Peterson's shorts, and he did touch them, and he rubbed his hands on them. There's a couple things that are critical to that. In listening to that, Mr. Rudolph then and there in the first trial was challenging how Mr. Peterson's clothing was secured the night that Mrs. Peterson died. He talks about it not being retrieved until 3 o'clock. He talks about the clothing being placed on a windowsill without anything to protect it. Officer George testified that the shirt and the pants were rolled up together and put in one bag, and that they were still moist. So from the very beginning, there have been issues with how evidence containing DNA or potentially containing DNA was handled. But what becomes more egregious and speaks bad faith on the part of the state is the actions of two individuals who have since been found by this court, or one of them at least, to basically have acted in bad faith in the past. Our Exhibit 40, which in the motion submitted to the court, it was Exhibit 34, was a request for examination of physical evidence. It was submitted by the Durham Police Department. It was submitted requesting DNA analysis and blood spatter analysis. And on that document, very specifically, and this was dated January 17th, 2002, that it was transferred to the SBI. In the comments and instructions, it specifically says, attention, D. Deaver and S. Barker. All clothing, shoes, and socks are to go to Dwayne Deaver and Susie Barker for blood spatter prior to DNA. suspect's socks and shoes need DNA so we can say they belong to M. Peterson. Excuse me. They were found by victim's body, pulled for pickup. So what occurred, first of all, is the clothing was moved over, first of all, to Dwayne Deaver and Susie Barker. They diverted the request of the Durham Police Department. They overrode it. They had the materials moved straight to them so that they could do their testing. That's bad faith. At that point in time, Mr. Deaver had his theory already laid out in his mind. And every step he took was an effort to further his theory. Now, my client's clothing was tested. That was very simple. When they arrived at the scene, he had blood on him. He had been holding his wife. He admitted to that. It was evident that he had been holding her. It's logical that her DNA from her blood and his DNA from his skin would be on his clothing. Very well. Exhibit 41.
So you say the bad faith wasn't necessarily the clerk's bad faith or even the district attorney's bad faith, but Dwayne Deaver's bad faith.
It's a chain, Your Honor. We've got a domino effect in this case. I don't think we've ever argued, and I may be incorrect, but I don't think we've argued that it's the district attorney's office's bad faith. But what we've got is an egregious violation of my client's due process rights. And it has dominoed. First, as seen in the video shown today, there's a question of how the evidence was collected to begin with. And Timothy Palmbach, going to the police department after it's all been processed and looking at it, is not party to how it was actually collected. What he is looking at is how is it being stored at this point in time? Does it appear to have been properly processed at this point in time when it's back at the Durham Police Department? But what we've got is there were questions to begin with as to how the evidence was collected. Then we had an intervening party, Mr. Deaver and Ms. Barker, saying, no, send us the materials to be analyzed. And for whatever reason, they determined that, yes, Mr. Peterson's clothes should be analyzed, but Mrs. Peterson's should not. Now, the argument that, surely the defense could have gone and had a separate DNA analysis done. Well, first of all, the defense at the first trial, as I understand it, challenged the DNA and its reliability because of collection procedures. But second of all, in trial, the state had they had the burden of proof beyond a reasonable doubt, but their theory of the case was that Kathleen Peterson was attacked, and she was attacked by Michael Peterson. And that is what defense had to defend against. At that point in time, the DNA was not that critical. The most critical part of the trial was what happened in the stairwell, what does the blood spatter show, were the state agents able to recreate what they believed happened in the stairwell. The jury said they did. Subsequently, many years later, 8 years later, we find out that the credibility, the truthfulness of Mr. Deaver is not only less than spectacular, but did not exist. So we come forward to this point. Mr. Devers' efforts, his testing, his recreations of the crime scene were, number one, absolutely inconsistent with those of Dr. Lee and Mr. Kalmbach. But second of all, they've been discredited. There's no one else from the State Bureau of Investigation at this point in time that will come in, I believe, and adopt whatever Mr. Deaver previously testified to. Therefore, it shifts to who did it, less of a how did it happen, more of a question of who did it. So how do you look at that? You look for fingerprints, you look for DNA, you look for whatever evidence there may be available. The victim's clothing was not tested. That was the start of the bad faith. There was a trial, Mr. Peterson was convicted. We're now looking at a new trial. We're starting from scratch. And as a result, at this point in time, we say, let us have the evidence and have it tested. Let's have it tested for DNA to see whose DNA is on Kathleen Peterson's clothing. We cannot do that. My client's due process rights, his right to be defended, his right to present a defense, his right to his right to defend himself has been totally undercut because at this point in time, we cannot have reliable DNA testing of her clothing. Now, it seems that the state is trying to say, well, it's the defense's fault because they didn't request it initially. I submit they questioned how it was done initially, but second of all, the thrust of the case driven by the state was he did it and this is how he did it. The DNA was just not the top priority. Now we're saying, we don't know how it happened. We've got our witnesses to say she fell, but wouldn't it be better and more appropriate to have taken the opportunity to take that DNA or do a DNA analysis, truthfully to have done it in 2001 or the beginning of 2002 and see what it showed? Did those clothes only have Kathleen Peterson's DNA on them? Did they only have Kathleen Peterson and Michael Peterson's DNA on them? Or do they have a third person's DNA on them? And we don't know that. We know the house was unlocked. We know that Michael Peterson was home, that Kathleen Peterson was home, and that she was found dead at the bottom of the stairs. And our efforts to represent Mr. Peterson are absolutely hamstrung because of the way the evidence was handled. And one other thing, Your Honor, if I may point out, perhaps. In 15A268, one of the things that is important to note as well is that it states that the one second, please. A custodial agency shall, doesn't say may, should, oughta. It says a custodial agency shall preserve any physical evidence, and emphasis added, regardless of the date of collection. When that evidence is reasonably likely to contain any biological evidence collected in the course of a criminal investigation or prosecution. Evidence shall be preserved in a manner reasonably calculated to prevent contamination or degradation of any biological evidence that might be present. It's not a coulda, woulda, shoulda, as Jim Moore used to say. It's a shall. And it was not done. I don't think it's necessary to say it's only the state's fault, it's only the SBI's fault, it's only the clerk of court's fault. What it is the situation is here, and because of the situation being presented to defense counsel, to my client, and to the court, there is nothing that can be done to restore his due process right to defend himself and present an appropriate and a fair defense. There is a due process violation, and it can't be overcome in this situation. And in regard to your question of Mr. Dornfried about if this case went to trial, yes, absolutely, we can, as a defense team, argue that the DNA does not exist or cannot be tested, that it was not properly preserved. But I would submit that's not enough. And I would submit that the state would argue, well, we know that Kathleen Peterson's DNA is on Michael Peterson's clothes, so that proves the case. And we can't disprove that negative of what was on her clothing. All we can do is throw out to a jury a little bit of supposition here and there. Well, maybe there was another person, but we don't have the answer. In hindsight, the state should have wanted to do that, to just close off that avenue, but apparently they had concluded that they could reconstruct what they believed to be the offense and that that was going to be good enough. Regarding the Youngblood case, one thing I would point out that is different in Youngblood versus a situation here. In Youngblood, a young child was molested, and a rape kit was conducted, but not preserved appropriately. However, in that case, they had a witness, and that was the child. And the child identified the defendant. In this situation, we have no witnesses. All we have is a woman lying dead at the bottom of the stairs, and no witnesses. That has so escalated the priority that physical evidence places in this case, or has in this case, that I would submit, Your Honor, that it is absolutely inapposite to argue that Youngblood drives the Peterson case. It does not. And therefore, we respectfully ask you to dismiss the charges against Michael Peterson. If you'd like to review the SBI reports.
All right.
Matt Roach.
Well, Mr. Dornfried, I don't know that you were expecting to argue again, but if I allow you to argue again, of course I will allow the defendant, though. Last argument. So Ms. Darrow says that the type of bad faith in Youngblood and in Dorman is different. There's never been a case decided that I can see that talks about the due process violation that the court can find under that state statute. But her argument is that it's not the kind of bad faith that Arizona versus Youngblood and State versus Dorman talk about. And this has never been a case, so I don't know. I don't know what the standard. I don't know what the legislature meant when they said if the court finds a due process violation. But you say you know because of Arizona versus Youngblood and
Well, it'll be the state's contention, Your Honor, that when we're looking at the bad faith must apply to the actions that are associated with the destruction or the tampering of evidence. If you have no bad faith in doing that, you're saying, well, something else that's ancillary to bad faith somewhere else that has no connection to the preservation of evidence, I believe that does not apply to the case.
she does make an argument, although she doesn't blame the DA.
We're thankful for that.
She says that Diva had bad faith.
And this goes along the lines of not just in Deaver, but we hear in other trials, that there's been tunnel vision, and investigators may have focused on one particular suspect. But here, when we're looking at a due process violation, we're talking about the destruction of evidence. And therefore, when looking at whether or not one is a good or bad fit, the intent of destroying that resulted in the destruction of evidence, it's irrelevant. It's a Brady, but if it's not a Brady, then you look to whether or not there's bad faith. And I would continue on that the bad faith has to be connected to the actions that resulted in the evidence being destroyed. In this case, the evidence that you've seen is that it was crossed out and that Mr. Beaver had the item set for blood pattern analysis. But then what happens? It goes back to the police department. Mr. Beaver's not involved in any way with the custody and control of that evidence at all. We have the witness from the defense saying at that point in time, it's exactly in condition that he would expect it to be. It's properly packaged. And so now there's a complete break as far as what Mr. Beaver's intentions were. Because now we have the items properly packaged at the police department with the opportunity for independent testing should it be desired by the defense. And then we have the items being introduced at trial. And Mr. Beaver has no control or no input. In no way is he connected with the evidence at that time. And therefore, Your Honor, we contend that the bad faith, that if there is bad faith, that's misplaced. It has to apply to the destruction or the alteration of evidence. I did want to just reference a couple of things as well. In 2001, 268 was enacted, but not as it reads now. And all the provisions that we're referencing, they weren't in existence back then. And it was as a result of subsequent enactments by the legislature in 2007 and 2009, which then put these additional requirements regarding the preservation of evidence. So in 2007, 2009, the trial was over. It's been 4 years, 6 years, and we don't know when these bags, when the boxes were moved and the items started to get in the condition that we see in the photographs. So I'm saying, granted, it does say it doesn't matter when the evidence was collected, but the requirements on the clerk, you're saying you can't go back in time, and if it's already happened, there's nothing to do that you can fix it. And even if there's a violation, according to subsection G of 268, it says if the court finds the destruction violated the defendant's due process rights. And then you go into the sanctions, which could include dismissal. So it's due process rights. Even if there is a destruction, we have to look at due process rights, which gets us back to Dorman and Youngblood. And again, Your Honor, we would contend that bad faith there has to be a nexus between the bad faith and the conduct that resulted in an alteration or destruction of evidence. And Mr. Beaver didn't have any nexus at that point, because at that point there's been a break. The items have been sent back to the police department, they're in custody there, they're properly packaged, They're subject to examination and have been examined visually by defense experts, and should they so desire, the opportunity for independent testing. And Your Honor, as I said before, counsel is not bound by the previous strategies, and it's a smart strategy to cover your bases. That's what she's saying she's doing now. They're saying it's an accident, but it's not an accident, he didn't do it. Previous counsel didn't do that. They just said it's an accident, and we saw how that resulted. But the potential is there. These weren't, these are seasoned, talented attorneys who knew that those were the options to take, that were available. And their strategy was to only take one route. And the fact that the opportunity was there, it had to take into consideration, according to Youngblood.
All right. I think Mr. Dornfried knows, you may know, you may not know, but in the last couple of years, I've had lawyers argue due process violation. A former Durham district attorney, not the present one. I sent 4 cases up there. All 4 of them were sent back because they said the due process violations that were established by defense counsel through the court weren't bad faith. Weren't bad faith for the same reason argued in Arizona versus Youngblood, and of course we've been talking about Dorman. That's one case that went up with the same thing. So the issue is the statute that says, the state statute that says that the court finds a due process violation, it can dismiss the case. It's important. So you say that there was that due process violation. I don't mind finding a due process violation if it's there, but the kind that they're wanting the court to find, apparently, since they reversed 4 of my cases, is the kind that Mr. Dornfried is arguing should be there. So the word due process violation does appear in that statute. I'm just trying to decide is it the same kind that you are arguing? And it either is or is not. And maybe that's something one of those courts is going to have to decide.
Your Honor, I think we're stuck only with due process, not bad faith. And I say that because there's 2 different sections of the statute that we're batting back and forth. But if it's knowingly and intentionally destroyed, if the evidence is knowingly and intentionally destroyed, you're looking at felony charges against the person who destroyed the evidence. I don't think that's applicable here at all. If there's a violation, as you said, of his due process rights, then you may consider dismissing the charges. So here is what we say has happened. As counsel, we are barred from preparing or presenting to a jury any form of effective assistance. Our hands are now tied as a result of what has happened to the evidence. We can't go into court and argue it was John Doe that was involved in this and caused Kathleen Peterson's death. Our hands are tied. We cannot overcome that in any manner whatsoever because the investigation was not done properly, because the analysis of Kathleen Peterson's clothing was cut off, stopped, diverted by members of the State Bureau of Investigation. That's the first part. Additionally, we can't confront or cross-examine if there is a John Doe. We can't present those witnesses. And we are not going to be in any position at this point in time to fully confront or cross-examination the multitude of people who have handled the evidence in the course of the trial. As Mr. Dornfried's own video showed, there were questions about the handling and processing to begin with, regardless of what happened prior to trial. As Mr. Pombach said, if it was done properly prior to trial, if the analysis had not been diverted and Kathleen Peterson's clothing had been checked for DNA and tested to see whose DNA was on it, it wouldn't matter if David Rudolph had thrown the shorts on the floor and stomped on them. It would not have mattered because an initial DNA analysis was conducted. Here we are in 2016, however, and it can't be done. And we can't say, oh, well, please refer to the report from the State Crime Lab that gives you the results, because they didn't test it. And that's where we are stuck. And that's where my client is harmed. And as such, we just can't adequately protect our client or present a defense of any sort in this case, other than to say he didn't do it. And that's not enough. It's not enough. We have one big question mark, and there are no clean hands, I would submit to the court, on what has happened with the evidence, whether intentional or not. There are regulations that say how to maintain and care for evidence once it's introduced in trial, never implemented. There are regulations or there are standard procedures for how to collect evidence at a scene. Police Officer George testified, he bundled it together. But most egregiously, it was not tested, and we are stuck with our hands tied behind our back, unable to find out what else might have been or is on Kathleen Peterson's clothing. And that's an injustice, that's an unfairness, and it's a substantive and procedural due process violation of my client's rights. Thank you, Your Honor.
All right. The court is going to determine that it does not find a due process violation. The defendant's motion is going to be dismissed. The state's going to prepare an order with the appropriate findings of fact and conclusions of law. And I need for you all to tell me when this case is going to be tried.
Can we have a moment to discuss?
Surely you've thought about it.
I have. We haven't discussed with counsel. Can we have a few moments first?
Sure.
And Your Honor, respectfully, we note our objection to your ruling
Yes.
for the record.
Can we have a recess? Because I don't want to do it in here. There's microphones and that. Okay.
Listen.
have a scheduling order before me, but in discussion with council, we've discussed the agreed upon May 8th, 2017 for a trial date. That's acceptable to the defense, and we can prepare a scheduling order at a later time.
All right. Now, Mr. Dornfried, one of your assistants was trying to get in contact with me. I told her I'd start 9:30 tomorrow on some matters she had. I won't try to do anything today. So
Okay, thank you. I'll
You
let
can
them
let
know.
her know that.
Yes, sir.
All right, any other business we got today?
Nothing but the statement.
Not this time, Your Honor.
All right, Ms. Stephanie.
Court's in recess till tomorrow morning at 9:30.
Yes, ma'am. What do you need? This is civil something. This is simple. This is civil.
Oh, okay. No, I don't know. I bet he does civil law, that's probably why. Okay.